Okay, this is People of the State of Michigan versus Maurice Day, docket number 20-568FC. Mr. Day, you are here on the people's motion to revoke bond, and also we have a pretrial, but I'll hear the people's motion first. How are we proceeding on this?
Your Honor, I'm speaking with Mr. Kuntz. I think we have a plea.
Oh, okay.
Which I don't know that it necessarily moots out the motion, but I think corresponds with it.
Wait a minute, something messed up happened on that.
We don't need that.
Okay.
Hold on, I got. Okay, I can't swear on Zoom. Okay. All right, so you said it's a plea, and this looks like to count 7, is that right?
Correct.
Did you fill out an advice of rights? I'm used to doing them orally because I'm doing all my pleas on Zoom, but you're in person, so I could use the form, actually.
No, Your Honor, we did not fill out the form.
Okay, if you could go through that,
That's
would be
fine.
fine then. Well, okay, if it's gonna take that long, I'll just do them orally.
Okay.
Mr. Day, I have an address for you on East Barney in Muskegon Heights, is that right?
Yes, ma'am.
Okay, how far did you go in school?
I graduated from high school.
Okay, and do you work right now?
No.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Day, you have the right to be represented by an attorney. You are represented by Mr. Kuntz. And Mr. Kuntz, this is a plea to count 7 only, correct?
That's right, Your Honor.
Okay, and will you waive reading of the balance?
We would, Your Honor.
Mr. Stevens, would you read count 7, please?
Thank you, Your Honor. People of the State of Michigan versus Maurice Day, docket number 20568FC, State of Michigan, County of Hingham. The name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about the date of February 20th, 2020, at or near the location of 2211 South Cedar Street, in the city of Lansing, Hingham County, the defendant did, in count 7, carry or have in his or her possession a firearm, to wit, a pistol, at the time he or she committed or attempted to commit a felony, to wit, weapons, firearms, possession by a felon, contrary to state law. This offense is known as weapons, felony, firearms. It is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of a weapon or device, and this offense would find the peace and dignity of the people of the state of Michigan.
Mr. Day, you're being charged here with possessing a firearm in the commission of a felony. That is a 2-year mandatory Michigan Department of Corrections sentence. It's not consecutive to any other charge because it's the only thing you're pleading to. But if you were on parole at the time, it would be consecutive to any parole sentence. Have you had enough time to talk about this charge with your attorney?
Yes, ma'am.
And do you understand the charge?
Yes, ma'am.
Do you have any questions about what we're doing?
I mean, I do, but it really ain't gonna make
Well,
a
no,
difference.
it would be important if you do. Questions for me about what we're doing or a question for your lawyer?
It's not really a question, it's just like a statement, because it's like, I feel I didn't bring a weapon, like, to the restaurant. The person I was with
Okay, maybe that's something you need to talk to your lawyer about, but the only thing they're saying, they're telling me that you're going to plead guilty to here
Oh, yes,
is just
ma'am.
possessing a firearm.
Yes,
Is that what you want to do?
yes,
And you understand what that means?
yes,
Okay, and how do you want to plead?
guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind and you'll be giving up the rights that go along with a trial. I'll go through those with you. It means you're giving up the right to a trial by jury, or if you didn't want trial by jury, trial by judge. It also means you're giving up the right to be presumed innocent until proven guilty, and the right to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as the right to have me order any witnesses that you might have to appear at the trial. Also, you're giving up your right to remain silent at the trial and not to have your silence used against you, or to testify at the trial if you wanted to testify. Also, when you plead guilty, it changes some things on appeal that you need to know about. First, you don't get an automatic right to appeal your case to the higher court. Instead, you have to ask them to hear your case. They have to agree to hear it. And then the other thing is that there are a lot of issues you cannot appeal when you plead guilty. Unlike if someone goes to trial, if they get convicted, they can appeal just about everything. So understanding those rights, you want to give up those rights and plead guilty?
I just got a quick, you said the judge, instead of like the jury, if I do go to trial, I can use the judge
Yes,
to.
you have a right to a trial by a jury, 12 people sitting in the jury box, or you can waive your right to a trial by jury and have a trial just by me, where only I would decide.
Yeah.
So
Ain't no possible way you could tell me, like, if I do go to trial and lose, what I'll be looking at, is it?
Well, I can only tell you what's on the information. So if you went to trial, you're looking at the possibility of being convicted of assault with intent to commit murder, a felony punishable by life or any term of years, assault with a dangerous weapon, a felony punishable by up to 4 years in prison, carrying a concealed weapon, a felony punishable by up to 5 years in prison, possessing a firearm when you're a convicted felon, a felony punishable by up to 5 years in prison. You've got then 3 separate counts of possessing a firearm during the commission of a felony. Each one of those is linked to one of those other felonies, and each one is a mandatory consecutive 2-year sentence. And then there's a habitual second offender notice. So I didn't add all that up, but it's a hefty sentence. I'm not saying that what I would do, I don't know what I would do. But, if you went to trial and got convicted of all that, you're looking at some very hefty offenses with mandatory consecutive sentencing on multiple offenses.
Okay. And with the jury, if I go to trial with the jury, it have to be all rules, right? Or is it majority rules?
I'm sorry, I couldn't hear you. It would have
I'm
to be
sorry.
all what?
If I want to go to trial with the jury, would it have to be like all the juries to agree on one thing?
Correct.
Or is it majority rules?
Correct. 12 jurors would have to unanimously, all of them agree on your guilt. They can not be unanimous on, they can say guilty on one count and not guilty on another, or any combination of that, but they have to all agree.
Okay. I'll just take the plea, because I don't want to play with my kids like this. I'll take the plea.
You want to go forward?
Yeah.
Okay. Now, if I accept your plea, it means you can't come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes.
It also means, and this is important, you can't come back later and say, I just changed my mind, or it really wasn't my own choice. That's why I'm taking the time with you to make sure that you understand what this is about, because you cannot come back later on and say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes.
Okay. Is there a plea agreement, Mr. Stevens?
Thank you, Your Honor. The defendant will be tendering a guilty plea to count 7, a successful plea and sentence to count 7. The people will move to dismiss the balance of the information.
Okay, so that's 1 through 6 and the habitual, correct? And is that a full and complete statement, Mr. Kuntz?
It is, Your Honor.
Mr. Day, is that your understanding as well?
Yes.
And again, do you agree with this?
Yes.
Okay, now, Has anyone promised you anything else that hasn't been said here right now in court in order to get you to plead guilty?
No.
Anyone used any threats to get you to plead guilty?
No.
Is it your own choice?
Yes.
And are you doing it because you believe you are in fact guilty of this offense?
No.
Okay, count 7, being a convicted felon, count 7, possessing a firearm during the commission of a felony, being a convicted felon is the felony. You feel you're not guilty of that offense. I'm not trying to badger you. I have to have you tell me what you did that makes you guilty.
Because it was just in the jacket I put on. I didn't bring the weapon. You know, it was who the weapon belonged to. It was his jacket. I just slipped it on the running side of the store. That's the
Okay.
restaurant.
Did
Once
you
I
know
got in
that there
there,
was a weapon in the
I did
jacket?
not. I wasn't aware until I got inside the restaurant and it was heavy. And I'm like, bro, your weapon's in the coat. He said, well, don't pull it out in the restaurant because I don't want them to think we're trying to rob. You know, so as soon as we got out the door, that's when everything took place. So we never got a chance to give him back his jacket.
Yeah, I don't care what took place out the door because, you know, the prosecutor's dismissing all these other charges. But did you at some point possess a weapon? And did you know at some point that you were in possession of a weapon?
Yes, when it was kind of too late to.
Kind of too late?
Yeah, because I was already inside the restaurant. And like he said, I didn't want to pull it out and they think I'm robbing it, trying to rob the restaurant. So I didn't want to just pull his gun out.
Where did the coat come from that you put on the
Out
jacket?
the car.
Your car?
Out the car that we was in, yeah, we were always together. I just slipped it on right because it was cold to run in the inside of the store. And the inside of the restaurant.
You didn't know that there was a weapon even in the car?
No, I did not.
Okay, so then I guess we will talk a little bit about what happened when you got outside. So you get outside, you realize that there is at some point a weapon in the coat.
Yes.
Did you then do something with the weapon?
No, I did not fire the weapon until I was attacked. That's it.
Do you want to talk to your client?
We've talked quite a bit. I don't know if the court would allow me some leeway in voir dire or.
You can ask him some questions if you
Okay.
want, but he's got to have knowing possession
Sure.
of it.
Right. So, Mo, you, inside the restaurant, you knew you had it, right?
Yeah, that's when I discovered like this coat was kind of heavy. And I reached.
How long were you, and then we're talking about Fleetwood Diner?
Yeah, we probably wasn't in the diner for no more than like 2 or 3 minutes.
In that 2 or 3 minutes, would you have had the opportunity to take it out to the car and not be in possession of it?
Since we got in the inside, like everything took place.
But it wasn't instantaneous, was it?
Meaning,
Like everything took place, right? So there was an argument that broke out, but it wasn't that minute, was it?
like, you could say that.
I don't think he can give a factual basis.
Okay.
Mr. Stevens, you want to proceed with your motion to revoke bond?
Yes, Your Honor.
All right, you can have a seat, Mr. Kuntz and Mr. Day at the table. And Mr. Day, I will advise you that this is the prosecutor's motion to revoke bond. Depending on what I find, it could mean that you have a bond revocation, or if I find that you've been in violation of bond, it could subject you to a contempt penalty of up to 93 days in jail. You can have a seat.
Thank you.
Mr. Stevens?
Thank you, Your Honor. I'll be brief because I outlined most of the details and the reasons in my motion. Clearly, the court understands and knows the charges that Mr. Day is facing, having just read through, albeit briefly, the current charges facing him when he was arraigned in the 54A District Court. Magistrate Wilmore imposed the bond condition that Mr. Day is not to possess or be in possession of any other firearms or dangerous weapons. And then from there, in my motion, I detail and it actually include a copy of the report from the Michigan Department of State Police record post in which Mr. Day is alleged to and frankly admits to being in possession of a firearm. That evidence is established by his own statements and Snapchat videos, which, if I recall correctly, he acknowledges during investigation with the state police. These are, I mean, that alone is a direct violation of his bond, given the nature of the current offense, the severity, the fact that we're talking about firearms in this case, and not only just possession, but also shooting firearms in Muskegon, that people would ask that Mr. Day's bond be revoked, please.
All right, Mr. Coons?
Thank you, Your Honor. Of course, this court obviously knows it has to look at two main factors when deciding what bond should be and, whether to revoke it. Is Maurice Day a danger to society, and is he a flight risk? And I think on the latter point, we can easily say, no, he's not. He's been to court every single time he's been asked to, since turning himself in on these charges, other than once, and that one time was my office's fault, not his, and we got it squared away immediately. So that's not an issue. Obviously, given the nature of this case and the nature of the allegations of the bond violation motion, that's a closer question. But I think the exercise we just went through prior to going on record with this motion, I think that more than anything illustrates if Maurice Day was a danger. He couldn't even give a factual basis on a 2-year felony firearm with the underlying felony of felon possession when he knows, because we've talked about it ad nauseum, that realistically the low end of his guidelines on the assault with intent to murder are 14 years, and that's only after he's done 6 years on felony firearm charges if we lose at trial. And so even though he wanted to take the plea, he couldn't do it, because the fact is he wasn't carrying with any sort of intent to harm anyone. He wasn't carrying with any sort of intent at all. And I think, a jury, a fact finder could differ as to whether there was knowledge there, but certainly wasn't any ill will intended that night. And then as far as the allegations with the new case out of Muskegon, that incident report is most notable for what it doesn't say. Now, I have not received discovery on the case. I haven't filed an appearance on that case or anything like that. But in talking to my client and then with his girlfriend, Tira Versa, who was also a witness there are two important things that weren't mentioned. One, the Snapchat video that was provided that led the police out to take a look in the first place. In that video, Mo was wearing completely different clothes, and it was taken from another day.
Well, Mr. Kuntz, if you're going to dispute what the prosecutor has put forth as the basis for the violation, which is the Muskegon County incident, then do you want a contested hearing on this?
Well, I guess, Your Honor, if maybe that's best, but I think in the interim, I also came in today thinking there would be a plea, and so that kind of complicated things. So, I guess in the interim, I would ask that Mo be able to stay out on bond. He's not. Even the new allegations have taken at face value. It doesn't indicate any violent action on his part. Obviously, if true, it's not good that he's around guns or firing them, but there's no violence. And again, he's been to court every single time he's supposed to. And just knowing that, this court isn't even starting trials till April, and I don't know how long this court's backlog is. I'd ask you to be able to stay on bond.
Time on February 22nd. Thank you.
Until this case can be resolved one way or another.
All right. I'm setting a contested hearing for Monday, February 22nd at 2:00. And in the interim, Mr. Day's bond is revoked and he's remanded to the sheriff.
I think I can bring the paper over here. Thank you.